it's not a... Yeah. The clerk will read the order of the day.
Private members' business item number 88 outside the order of precedence relating to the Limitation Amendment Child Abuse Bill. Mr Shoebridge.
Yeah, that's right. Sorry, Mr David Shoebridge. A bit distracted.
Mr Deputy, I move that leave be given to bring in a bill for an act to amend the Limitation Act 1969 to remove the limitation period for bringing civil proceedings in relation to child abuse.
Oh, sorry. The question is... Oh, sorry. The question is the motion of the member. All those in favour, please say aye.
Aye.
Those to the contrary, no. The ayes have it. The ayes have it.
Okay. Mr Deputy President, I present the bill and move that the bill be read a first time and printed.
The question is that the bill be read a first time and printed. All those in favour, please say aye.
Aye.
Those to the contrary, no. I think the ayes have it. The ayes have it.
Limitation Amendment Child Abuse Bill 2015, first reading.
Mr Shoebridge.
Mr President, I move that this bill be now read a second time. Victims and survivors of child sexual abuse look to their elected representatives for justice. Knowing that, this bill endeavours to deliver one important and much delayed reform, to deliver that exact request that victims so desire, deliver some substantial reform to justice. The object of this bill is to amend the Limitation Act 1969 to remove any limitation period applying under that Act on a cause of action for damages that relates to the death or personal injury of anyone resulting from child abuse. This Parliament has an obligation to deliver practical assistance and real legal remedies so that victims and survivors of child sexual abuse, whenever that occurred, have it within their power to gain access to justice. While the Royal Commission into Institutional Responses to Child Sexual Abuse is ongoing, and I commend its work, there are simple changes that can now be made that will immediately help those victims and survivors of past child sexual abuse. In a context where the average time for disclosure of child sexual abuse is approximately 23 years, it differs slightly for men and women. The 3-year time limit for civil claims for compensation is a serious and inevitable obstacle to justice. Victims and survivors of abuse have enough challenges in their way coping with the effects of the abuse. So, wherever possible, the law, and especially our limitations laws, should not add to the burdens that they already have. Currently, to make a civil claim out of time, that is beyond the 3 years after which a child victim of abuse has turned 18, a survivor must seek the leave of the court to allow their claim to be brought out of time. And we know, anyone who's looked at it knows, anyone who's spoken to the lawyers who act in this jurisdiction, or the victims and survivors who have sought compensation know, that defendants use the existence of the statute of limitations to beat down victims and survivors to reduce the amount of compensation they have to pay. In the very first settlement conference, when a survivor of abuse is sitting across the desk from the lawyers and the representatives of the institution that they say abused them, often the first thing that's raised in the settlement negotiations is, well, I'm terribly sorry, but you're out of time. And you're going to have a great deal of difficulty convincing the court to extend time in which to bring this claim. Therefore, we'll offer you 50% of the value of your claim, or 20% of the value of your claim. And time after time, victims and survivors are beaten down in those negotiations, and the law should not give the institution that abused them that power. While access to the leave of the court to bring a claim out of time has allowed many victims to seek justice, it should, as a matter of principle, not be at the discretion of judges to allow for this extension. Survivors of abuse ought to have a substantive right to their day in court on their claim. And we cannot and must not allow technicalities to stand between victims and access to justice. This bill relates to civil claims for the very simple fact that compensation is recognised by everybody as an important part of the healing process for many victims. The report from the Victorian inquiry, the Victorian Parliamentary Inquiry into institutional responses to child abuse, was presented to that Parliament on the 13th of November 2013. That report identified the operation of the statute of limitations in Victoria as a substantive obstacle to victims seeking redress. And the Victorian Parliament acted. The Victorian Limitation of Actions Amendment Child Abuse Act 2015 came into operation on the 1st of July 2015, months ago. And in that state, it has removed the operation of the statute of limitations for all civil claims relating to child sexual abuse. And it has expressly made that change retrospective. The Royal Commission into Institutional Responses to Child Sexual Abuse on Monday this week handed down its final report into redress and civil litigation. And I've got to say, it was an extraordinarily important report, some 600 pages long, deep research, carefully considered recommendations, and of course, in the political maelstrom that was Monday, with the political removal of former Prime Minister Abbott, the installation of the new Prime Minister Malcolm Turnbull, that extraordinary piece of work from the Royal Commission did not receive the attention it was due. And victims and survivors, I think, have been greatly disappointed, and rightly so, that important piece of work, proposing a national redress framework, proposing essential reforms to our civil litigation system so that victims and survivors can stand on a near equal footing with the institutions that abuse them, has not been given the attention that it deserves in our state and national media. And I would urge all members, if they haven't, to at least read the executive summary of the report and digest the work that's been done by that Royal Commission, founded on the best expert advice, but also hundreds and thousands of case studies from victims of abuse. It is essential reading for anyone who professes to have a genuine interest in delivering justice for victims of abuse. But the Royal Commission found that the statute of limitations, not just in New South Wales, but in each state and territory across the country, and indeed at a federal level, that statute of limitations is an inappropriate and unfair obstacle to victims of child sexual abuse seeking civil redress. And the Royal Commission made, amongst many recommendations, the following recommendations. Recommendation 85 was that state and territory governments should introduce legislation to remove any limitation period that applies to a claim for damages brought by a person where that claim is founded on the personal injury of the person resulting from sexual abuse of the person in an institutional context where the person is or was a child. Recommendation 86 was that state and territory governments should ensure that the limitation period is removed with retrospective effect and regardless of whether or not a claim was subject to a limitation period in the past. Those recommendations are clear and compelling, but without action from parliaments, without law reform, they will ring hollow for victims. This bill seeks to make the exact change that was implemented in Victoria and deliver on the recommendations of the Royal Commission. In New South Wales, we often hear recommendations such as came from the Royal Commission and then proceed to undertake a further inquiry into possible changes. And then Parliament receives another report, or government receives another report, more meetings are held, further delay happens, and then, at best, years later, we introduce a change to the law to give effect. This time, we don't need to do that. This time, we've seen what's happened in Victoria, and we have the Victorian model to follow. This time, we have the clear and compelling policy support that's been delivered by the recommendations from the Royal Commission. The Royal Commission recommends this change. Victoria has already done it. We can do it here too, and we can do it now. With cross-party support, we can deliver this long-awaited reform the very next day this Parliament meets. The Limitations Act currently puts in place a time limit of 3 years from the date that the survivor of abuse reaches maturity, which is 18 years of age. 3 years in which to make a claim. In general, such limitations are designed to facilitate the resolution of matters within a reasonable period of time. And as a general principle in the general law, there is a strong policy reason to have in place a statute of limitations. That ensures that wherever possible, claims are brought where the events that are relevant to the claim are fresh in the mind of the witnesses. And there is, as I said, good public policy reasons to support a statute of limitations in the broad. However, in the case of child sexual abuse, the research and the study and the history proves that the limitations period of 3 years, indeed any limitations period, is highly inappropriate. We know that the average time for disclosure for victims of child sexual abuse is in the order of 23 years. As I said, for male victims it can be slightly longer. For female victims, some studies have suggested it is marginally shorter. But the average time is in the order of 23 years. And of course, the time in which any individual will be able to talk about or disclose or seek action for redress for the injury that happened to them will depend enormously on the personal situation of the victim. And in that context, everybody who has looked at it, apart from some institutions who want to defend their own wealth, who want to defend the status quo and have a law that allows them to beat down victims when they bring a claim for compensation, apart from a handful of institutions, which even as I speak, that handful is getting smaller and smaller as the case for reform is building. There is literally no one who's looked at the issue who supports the retention of statute of limitations for child sexual abuse claims. And although some organisations do not seek to rely upon the statute of limitations, and I note that after being grossly embarrassed by the appalling manner in which the state of New South Wales exercised the defence of a statute of limitations against a number of children who had been abused in the care of the state decades ago, that the New South Wales government has now made a policy, not a legal position, but a policy position not to use the limitations of defence in relation to child sexual claims. And other institutions have chosen voluntarily to restrain themselves and not rely upon the limitations defence. There are, to this day, many institutions who continue to rely upon the defence to defend their claim. And I want to be clear. No survivor of abuse should be reliant on the goodwill of the institution that abused them in order to bring their claim for just compensation. No survivor ever should be in that situation. But tragically, that's the situation the law currently places them in. Some research in Australia that has been gathered by Bravehearts show that the figures in relation to delay are reasonably consistent across Australia. In Queensland, the Project Access survey undertaken by Bravehearts found that of 212 adult survivors of child sexual abuse, 25 of them took 5 to 9 years to disclose it, 33 of them took 10 to 19 years, and 51 took over 20 years. The time taken to disclose can be substantially longer where the perpetrator is a relative. The Queensland Crime and Corruption Commission found of 3,721 reported offences committed by relatives that 25.5% of survivors took 1 to 5 years to report the acts, 9.7% took 5 to 10 years, 18.2% took 10 to 20 years, and 14.2% took more than 20 years. This data shows that even a 20-year statute of limitations would exclude many victims who, through no fault of their own, and often by reason of the damage that was occasioned to them as a result of the abuse, would not be able to bring a claim for compensation in that time frame. And indeed, sometimes the most damaged individuals are the ones that are least able to bring their civil claim in a timely fashion against the organisation that failed to protect them. They should never have to pay an additional penalty as a result of this. And if I was to think of just one instance, one individual who made contact with my office that demonstrates this, it occurred some 3 years ago after my office and the Newcastle Herald held a public event in Newcastle, in the Workers' Club at Newcastle, where the question was, should there be a Royal Commission into child sexual abuse? And we weren't sure how many people would turn up. We promoted the event and we'd set out some 100 seats. But when I turned up 10 minutes before the Workers' Club opened, there was already a crowd out the front. And once we opened the doors and we started setting up the seats, we had 100 seats set out, more and more people came. More and more people came. More seats were put out, more people came. More seats were put out, more people came. The auditorium was full to bursting. People were standing at the sides. And in that event, after we heard from Peter Fitzsimons, after we heard from Peter Fox, an extremely brave former New South Wales police officer, we heard from survivors and the families of victims of abuse, and a compelling case about a tragic circumstances where a survivor of abuse had taken his life only recently in the Hunter. Many individual victims got up and spoke in a very emotional moment, and they came one after the other and spoke about the abuse that they had suffered and the need that they had to get some justice. And at that time the call was for a Royal Commission. As I was travelling home, I think after I'd come back to Sydney, I got a call from an elderly gentleman who had been at that event, and he'd said how emotional it was, how he'd come with his wife, and his wife of some 40 to 50 years. And he said that it was only after that event on the way home that he'd ever had the courage to speak. Not the courage, but he'd ever found it within himself to be able to speak and disclose about the abuse that happened to him. And for me, when I remember back at that conversation, I thought at the time, that limitations bill must go. We must act to ensure that people like this have access to justice, and of course we should, and of course we should deliver on it, and that's what this bill does. What does this bill actually do? Well, Schedule 1, Clause 1, excludes an action on a cause of action for damages that relates to the death or personal injury resulting from child abuse from the operation of the Limitations Act, removes the limitations provisions, and accordingly it would make the bringing of proceedings on such causes of action not subject to any limitation period that's provided for in the Act. The common law provides no limitation period, so removing the statutory prohibition would remove the limitation period at law. The proposed provision is expressed not to limit, and nor should it, any existing powers or jurisdiction of the courts. For example, the power or jurisdiction to stay or dismiss proceedings where a court determines that the lapse of time has a burdensome effect, it's otherwise vexatious on the defendant, and the burdensome effect is so serious that a fair trial is not possible. Schedule 1, Clause 3 makes it clear that the exclusion of such actions from the limitations periods applying under the Act extend to existing causes of action and include causes where the relevant limitation period has already expired. It also ensures that the bill applies to past causes of action. And in that regard, I note that the proposed new sections 9 and 10 in the Act would read as follows. Section 6A, which is the substantive provision which removes the limitations powers for the limitations provisions for actions for the recovery of damages for child abuse, provides that Section 6A applies A, whether or not any limitation period previously applying to the cause of action to which Section 6A applies has expired, and B, whether or not an action has been commenced previously on the cause of action, and C, whether or not a judgment on the cause of action has, on the ground that a limitation period applying to the cause of action had expired, been previously given, and D, whether or not a judgment in respect of legal professional negligence has, on the grounds that a limitation period applying to the cause of action had expired, been previously given. The proposed Section 10 relates to pre-existing judgments and settlements and provides, in part, subsection 1, an action on a previously barred cause of action may be brought even though A, a judgment on the cause of action has, on the ground that a limitation period applying to that cause of action had expired, been given previously, or B, a judgment in respect of legal professional negligence has, on the ground that a limitation period applying to the cause of action had expired, been given previously, or both. And the proposed subsection 2 of Section 10 provides that an action referred to in subclause 1 may be brought as if the action in which such a judgment was given had not itself been commenced. In other words, for those individuals who have suffered an unjust outcome, and inevitably in relation to child historical sexual abuse, where their claim has been dismissed on a limitations defence, that is an unjust outcome. That unjust outcome will not bar them from bringing a claim if this bill becomes law. We have consulted widely with this bill, and we note that we have received endorsement of the bill from the following organisations and individuals. We have support from the Indigenous Social Justice Association. We have support, and it's support in his personal capacity, from the Honourable Hal Spurling. We have support from Bravehearts. We have support from SNAP, the Survivors Network of those abused by priests. We've received support from the Women's Legal Services New South Wales. We've received support from SAMSON, which is the Survivors of Mates Support Network. And we've received support from ASCA, the Adults Surviving Child Abuse. Each of those organisations does essential and important work. Each of those organisations, I think, has the full respect of members in this chamber. And each of those organisations supports the very law reform that we're putting forward. And I'll just briefly read, I'll briefly note that when we consulted with Bravehearts on this matter, that the CEO of Bravehearts, Ms. Hetty Johnson, an indefatigable campaigner in this area, notes that not only does the bill have the support of Bravehearts, but their position on the matter has been clear. And as they say, it's a position we have held for over 15 years. And their position is that the statute of limitations, when it applies to child sexual abuse matters, is, in their words, draconian and must disappear. Victoria has already done this, and we predict that the Royal Commission is going to recommend all states and territories do the same. I actually think this legislation has a shelf life of about 3 nanoseconds, says Ms. Hetty Johnson. Well, let's hope that's the case. Let's hope that's the case. Because with cross-party support, we can make this bill law the very next day that this Parliament meets. We thank all of those survivors and victims who have contacted my office, the organisations that have contacted my office, for their support and their ongoing courage to insist that the law is changed, not just so that their case or their claim, which is often well and truly resolved by now, can be given a fair hearing, so that all future claims can be given a fair hearing and justice according to law, not justice at the discretion of the institution that abused them. Reform is needed now, and this widely supported and essential reform can ease at least one burden, and it can ease that burden for victims immediately. I call on all parties in this Parliament to support this bill because there is a simple political fact. Doing nothing in the face of injustice places those in power on the side of the abusers. It's time we stood firmly on the side of victims and survivors. I commend the bill.